Welcome to Coffee Talk, our health seminar series. My name is Kathryn Frelick, and with me today is Lauren Parrish. Today we have the pleasure of speaking to you about institutional obligations to mental health patients and to staff. And when we talk about obligations, we're talking about obligations, challenges, and strategies for working in this very complex area of the law. So without further ado, we have presented a bit of an overview of what we're going to speak to today. First, we will talk about some of the sources of mental health law. We'll discuss some of the common challenges, both generally and then with respect to Schedule I designated psychiatric facilities, as well as non-Schedule I facilities. Finally, we're going to talk about some strategies to manage legal obligations, given the many legal requirements that are sometimes conflicting that organizations have to deal with, and the other constraints that organizations are under as it relates to resources and other competing demands. So the slide that we're presenting now just shows an overview of some of the sources of mental health law. And it really will depend on the type of organization as to which legislation will apply. The Mental Health Act, of course, applying to designated psychiatric facilities, the mental disorders provisions of the Criminal Code, which apply to designated hospitals, which have forensic mental health programs, Occupational Health and Safety Act, which applies to all organizations, and then in the vast majority of cases, Schedule I facilities are also public hospitals and are governed by the Public Hospitals Act. We will not be going into all of these sources in detail, but we will highlight some of the key driving pieces of legislation in some more detail. I think it's also important to realize that particularly in the mental health area, there is a lot of litigation, a lot of the requirements and legal obligations are stemmed in the common law or case law, as well as inquests and other types of legal proceedings. So more than any other area, I think mental health law is really shaped by those factors where we're dealing with patient rights and there's a very active patient bar. So our very first important takeaway is really to know the authority under which the individual is being treated, because the rights and the responsibilities all flow from this. And you'll see that as we go through our examples. We're going to start off with a brief discussion about the Mental Health Act, which applies to every psychiatric facility. These are defined as facilities for the observation, care, and treatment of persons suffering from mental disorder, and designated as such by the minister. The Ministry of Health and Long-Term Care has a listing of all of the designated Schedule I facilities, which are facilities that are required to provide 5 essential services unless there's an exemption. The Act governs patients who are being treated in a designated psychiatric facility. The designation follows the patient, so it's really important to recognize that when a patient is being admitted as a patient under the Mental Health Act, they may be in another area of the hospital, it may be a medical floor, but the designation really relates to that patient, wherever that patient may be. There are numerous statutory obligations set out under the Act, and there are particular roles for the officer in charge, who's the person who's responsible for the supervision and care in the psychiatric facility, as well as the attending physician, which is a defined term which is used throughout. The Mental Health Act is an extensive and complex piece of legislation. As you know, it governs things such as involuntary detention, the use of restraints, searching patients. The underlying premise of the legislation is it's intended to be remedial in nature and should serve as a vehicle for protection of mentally ill persons. And because of that, there are a number of statutory protections for patients that are built into the legislation. One of the key areas relates to the assessment and admission to hospital of patients under the Mental Health Act. They may be voluntary informal, which is a patient who is being admitted with the consent of substitute decision maker on a voluntary basis, or involuntary. It may occur by police apprehension. It may occur by court order, and the status may change during the course of admission. The intersection of so many different agencies in order to bring a person to hospital, whether it's individual practitioners and physician offices, community mental health, families, police, outside agencies, emergency services, all of those players and stakeholders may have a role in the ultimate assessment and admission to hospital of a person. The next piece of legislation we're going to spend a little bit of time on is the Charter of Rights and Freedoms. The Charter does not apply to every organization. It applies to government and government agencies. Most health organizations are private corporations that are publicly funded. And the Charter doesn't apply to private organizations. It may, however, apply to private entities where you are carrying out a statutory authority or where you are carrying out a government program or policy as it relates to the provision of that policy. So when we're dealing with the Mental Health Act, and particularly the authority to detain individuals, those activities are subject to the Charter, and organizations may be subject to a challenge by a patient. We've listed a number of relevant Charter provisions that often occur in the mental health context. Just a few examples. Section sub 2B relates to freedom of expression. This often comes up when it relates to access to sexually explicit material or pornography, the ability for patients to express themselves. Section 15 deals with equality under the law. This is often comes up in the context of discrimination claims and concerns about unequal treatment by individuals. Section 8 deals with protection against unreasonable search and seizure. There are a number of different types of searches that are often conducted in mental health facilities, and both of rooms and of patients to keep individuals safe. And those are the provisions that really relate to how those searches can be done. It's important to realize that even where the Charter does apply, it does recognize that there may be circumstances where an organization is justified in violating an individual's rights. But in doing so, the limit must be something that's prescribed by law. So it could be found in the Mental Health Act or in the Criminal Code. And it must be demonstrably justified in a democratic society. So typically when we're looking at the potential infringements of rights, what an organization needs to be able to demonstrate is that they've looked at the right, they've looked at other alternatives, whether the infringement is minimally impairing, there's a whether there's a rational connection between the infringement and essentially a balancing of those rights to make sure that there's a reasonable justification for infringing on those rights.
The Criminal Code is also a piece of legislation that interacts with mental health and mental health care, and it has its own specific section that sets out those provisions. Those provisions govern the assessment, detention, and release of persons who have been found either unfit to stand trial by reason of a mental health issue or not criminally responsible for a crime by reason of a mental disorder. And this regime under the Criminal Code for mental health is often referred to as the forensic system or the forensic mental health system. So when you hear those terms, that we're referring to the Criminal Code regime. Under the Criminal Code regime, an individual can be detained in a designated hospital in two main situations, which I've just set out. One is where they're found unfit to stand trial, and two is when they're found not criminally responsible for a crime because of a mental disorder. So where an accused is found unfit to stand trial, the court may issue what's called a treatment order, and this allows the accused to be detained in a psychiatric facility for a period of time that cannot exceed 60 days and receive treatment such that they may become fit to stand trial. So this is the rare and quite unique situation where the court can order a patient to receive psychiatric treatment without their consent. There are limitations. The treatment cannot include psychosurgery. It can't include electroconvulsive therapy. And also, the court must seek the consent of the person in charge of the hospital where the accused will be detained for that treatment before making such an order. And we'll go into a case that discusses this in a bit more detail in a few slides. Where an accused is found not criminally responsible for a crime, the court and later, potentially the Ontario Review Board, can issue a detention order. And in the case of a high-risk accused, this type of order must be issued. So the ORB needs to review a court-issued detention order within 90 days. There's a fair bit of discretion as to what sorts of conditions can be associated with a detention order. But where the court is the body that makes the order, the board, the ORB, must hold a hearing and make a disposition within 45 days. And that's in situations where no detention order has been issued. The Human Rights Code, also an important piece of legislation, and on the slide in front of you is the wording of Section 1. Section 1 of the code sets out a key provision, and that provides every person with the right to equal treatment in respect to services, goods, and facilities without discrimination based on an enumerated ground. And you can see the various enumerated grounds listed on the slide in front of you. They include things such as race, ethnicity, sexual orientation, and disability. And disability is really what ties this provision to mental health. A mental illness is considered a disability within the meaning of Section 1 of the Human Rights Code. And because of that, an institution cannot discriminate against someone on account of a mental health disability. The Ontario Human Rights Commission has a comprehensive policy dealing with prevention of discrimination based on mental health disabilities and addictions, and this is certainly an area of focus, and the Human Rights Tribunal is seeing quite a bit of activity with respect to issues of mental health disability. The Human Rights Code is an important piece of legislation because it imposes what's called a duty to accommodate. So we know that it prohibits discrimination. The first question is, what is discrimination? And the code sets out a two-part test, whereby discrimination will be found to occur if there's differential treatment based on one of the enumerated grounds. So in the case of a mental health disability where an individual is treated differently on account of their mental illness, this will amount to discrimination, and it will trigger what's called a duty to accommodate. Determining whether the duty to accommodate is triggered is nuanced in the mental health care context specifically because with respect to patients, it's quite likely that all mental health patients in an institution are considered to have a mental health disability. And so the question really is around the issue of differential treatment. The duty to accommodate is generally triggered by a standard or a rule that when applied uniformly has the effect of causing one individual or one small group of individuals to experience differential treatment. Even where the duty to accommodate is triggered, however, an institution can show that it has satisfied that duty and has in fact accommodated an individual or a group in a specific situation. And on the slide in front of you are the 3 steps that must be met for an institution to show that it's accommodated sufficiently under the Human Rights Code. So you need to demonstrate that the rule that's causing the differential treatment was adopted for a purpose that's rationally connected to the function being performed. So it needs to have some rational basis for the implementation of the rule in the first place. The rule needs to be adopted in good faith. There has to be an honest belief that it's necessary to fulfill the purpose that the institution is saying it's there to fulfill. And it has to be a rule or a standard that's reasonably necessary. So even if in good faith an institution might think that such a rule or standard is a good idea, it has to be shown that it's actually necessary and that it's impossible to accommodate the person experiencing discrimination without what's called undue hardship. So undue hardship is an interesting concept, and it's there to demonstrate that the duty to accommodate, it's not endless. An institution only has an obligation to accommodate someone up to the point of undue hardship. And when determining what would amount to undue hardship, the Human Rights Tribunal will consider the costs of accommodation, whether there are outside sources of funding that can be accessed to assist in facilitating accommodation, and whether the accommodation affects health and safety. Again, this is a fact-specific analysis. But one thing I do want to highlight that's important to remember is that the Human Rights Code and the duty to accommodate, it applies, of course, to patients, but it also applies to staff. And that's an important thing to remember. So if, for example, a staff member is experiencing a mental health disability, the institution as the employer would also have a duty to accommodate that person in the workplace. And the last piece of central legislation we just want to touch on is the Occupational Health and Safety Act. This applies to all institutions, and it applies with respect to employees and staff. It's quite detailed piece of legislation, and it imposes a number of specific obligations on employers with respect to ensuring a safe working environment for staff and employees. And you'll notice that we've highlighted the wording of this legislation. It's not it's definitive. It's setting out obligations that employers must do, and it's quite specific. So you must take every precaution reasonable in the circumstances for protection of the worker generally. And more specifically, you must prepare written policies with respect to workplace violence and harassment. The policies must be reviewed annually. Beyond that, a comprehensive program to implement the policies on violence and harassment must be developed, and the employer must assess the risks of workplace violence. So it's quite a broad scheme. There's a number of obligations, and they are quite important and do come up, and they'll be discussed further in one of the cases that we're going to talk about.
So why have we gone into all of this detail? Well, there are, as we said, one of the first things that you need to understand are what are your obligations from a legal perspective? What are your obligations to patients? What are your obligations to staff? And what are your obligations to the public? And once you've identified those, there is a need to balance those competing obligations. In some cases, there may be conflicting obligations under the law. Essentially, there are a number of things that you could do when you're looking at initiating a new program or an initiative or policy. The first step is really to undertake a risk analysis and to weigh all of the competing factors before you arrive at a decision related to that policy or that program, and document that analysis so that if you're challenged in the future, you can demonstrate that you exercised your due diligence, you looked at the various considerations, you looked at the various tests that we set out where there are potential rights that might be infringed, and you are placing the organization in a defensible position. And there are ways to do this systematically so that you do have the ability in the future to be able to demonstrate that we thought about these issues. We really considered them, and this is where we landed. So one of the common issues that all organizations are facing relate to workplace safety, and there are many examples in the media and in various inquests relating to the issue of workplace violence in the workplace and harassment. There were changes to the Occupational Health and Safety Act, and after the case of Lori DuPont, the Windsor nurse who was stabbed to death by one of the physicians, and requirements that really beefed up the obligations on employers to ensure that there is a workplace violence program in place to protect staff. One of the most recent cases where they've considered these issues related to the Royal Ottawa. This was a forensic mental health floor where a nurse was assaulted by a mental health patient, and a number of charges were brought against the Royal Ottawa. In looking at the obligations of the organization, the court looked at the structure of the workplace violence program that the organization had in place, including its Code White policy. One of the focuses of this particular case was on whether there were adequate measures in order to for individuals to summons help in the event of an event, And in this case, the court found that the hospital had discharged its duty under the Occupational Health and Safety to ensure staff safety because it did have adequate measures in place. Now, again, this is a very fact-specific analysis. This was a very detailed process that the Royal Ottawa had to go through, and at the end of the day, these measures were found to be reasonable. It will also depend on the nature of the facility and the types of patients and risks that are present. We're now going to talk about some of the special challenges for psychiatric facilities. Where you have the power to lawfully detain individuals, there are a number of checks and balances that are built into the legislation. There's a need to be able to demonstrate compliance with statutory process and timelines. And that really requires that you have appropriate policies and procedures, delegation of functions, whether it's the attending physician or the officer in charge. The officer in charge can't be present 24/7 in a psychiatric facility, so there needs to be processes for delegation. And the importance of all of this is if those processes are not in place, it could result in a form being invalidated and potentially an individual who requires help to be released. It could also result in other legal proceedings which you would then have to defend. We've set out on the next slide some of the process that needs to be followed under the Mental Health Act when you are looking at involuntary detention. And in each step, there are different tests that need to be applied, different criteria, and the timelines are all very specific. The patients have a number of rights that are built into the process at various stages, where a patient is being held on an involuntary basis. They have the right to know the reasons for the detention, the fact that they're entitled to a hearing before the Consent Capacity Board. They have the right to retain and instruct counsel. And for long-term detainees, the fact that the patient has a right to request that the Consent Capacity Board make one or more orders. And this is when we get to the mandatory stage after a number of different recertifications. And one thing that we are seeing is that the order-making authority potential is extremely broad under the Mental Health Act. The applicant can request orders relating transfer to another facility, relating to their level of privileges, relating to their programming, and a host of other different factors, which has really changed the process considerably to be much more akin to the ORB process, but has also made it very legally complex because it does require additional parties to be present. If there's a transfer application, then the receiving facilities are also part of that hearing, and so there's a real additional complexity for organizations around these authorities. The patient has a right to access to a rights advisor, whose role is really defined under the legislation. And there are, again, there are potential consequences if these rights are not respected in the proper order, and a patient's rights have been potentially compromised. One other area that is also fraught with risk relates to assessments of financial capacity under the Mental Health Act. And there is an obligation upon admission for the attending physician to assess capacity for managing finances. This is an area where if that's not done, an incapable person is there and their assets are potentially at risk. We have certainly seen situations where the public guardian trustee has intervened, where that process wasn't followed, or where when an individual was being discharged, the public guardian trustee did not receive notification, so that they can continue on in that role.
On the slide in front of you are 3 types of orders that can be made under the criminal code regime, and I've touched on them briefly, but I'll touch on them briefly again. The assessment order is just what it sounds like. It authorizes a psychiatrist to assess an accused to determine whether they have a mental illness. Now, the assessment itself can occur without consent, but no treatment can take place without patient consent. A detention order is what authorizes an accused to be detained in a psychiatric facility. Again, consent is required for treatment, which can pose some issues where we kind of get into the revolving door ongoing detention situation without any ability to treat a patient. The treatment order, which we did touch on, this is the rare situation where no patient consent is needed for treatment. The treatment can't exceed 60 days, as I discussed. And the interesting, unique part of this is that the court or the ORB or whoever is issuing the treatment order must seek consent of the person in charge of the treating facility. The ORB can order involuntary detention, and it can also delegate authority to the person in charge of the hospital, and that authority would be to decrease or increase the restrictions on the liberty of the person who is being detained. This is another authority that is granted by the criminal code. However, with it comes obligations on the part of the person who is receiving that delegated authority. So when there has been an increase in restriction on liberty of a detained accused that significantly increases the restriction, the person with delegated authority must record the increased restriction, and it must also give notice to the ORB as soon as practicable and no later than 7 days after the increase in restriction has come into effect. Where the ORB receives such notice of an increased restriction in liberty, it's required to hold a hearing also as soon as practicable, and no longer than 30 days after receiving notice. And that's for the purposes of reviewing the change in conditions and ensuring that it can provide a mechanism to monitor these changes to a patient's liberty in order to ensure that liberty is infringed only to the extent necessary to protect public safety. The notice requirement was recently considered this year by the Ontario Court of Appeal. So we know that a person with delegated authority must notify the ORB if restrictions on a detained person's liberty have increased significantly. But of course, the question becomes what amounts to a significant increase? And the answer, which is one that we often give, is that it depends on the facts of the case. So it's really a case-by-case fact-specific analysis, but the Court of Appeal did flesh out the issue in the Campbell decision. Now, the Campbell decision, the appellant was found not criminally responsible of a crime in 2004, and she spent 10 years following that in the Brockville Mental Health Center. The ORB then reviewed her to be transferred to the Royal Ottawa Mental Health Centre and detained in that facility's secure forensic unit. And while there, the appellant began to have some challenges with drugs and alcohol, and in an effort to control her behavior and to assist in her treatment, she was removed some of her privileges, and she was eventually transferred from one secure unit to a more secure forensic unit. The appellant brought a challenge to the court, and she argued that this transfer was a violation of her Section 7 charter right to life, liberty, and security of the person. So 2 months after she was moved from one secure unit to a more secure unit, the hospital did notify the ORB that she had been moved, and the court considered this, and it considered whether the move from one secure unit to another was a significant increase on this patient's restriction on liberty. And they identified a new test as to how one considers what is a new and significant increase in restriction on liberty, and it's been called the liberty norm test. So a liberty norm really relates to what an individual was actually experiencing before there was an increase in restriction, as opposed to what they might have been entitled to. So it's really trying to get a sense of what was this patient's day-to-day life and what rights did they have in their previous situation. That is the liberty norm. The liberty norm then must be compared to their liberty status following what is being suggested to be a significant increase in restriction. And that's how you compare and try to make a judgment call as to whether the increase in restriction is significant. So the court did note that the hospital has the option of simply informing the ORB about a decision that has changed an accused's liberty status. And this doesn't have to be a formal notification that formally triggers a hearing and constitutes official notice. It can simply be giving that information to the ORB, and the ORB then, if it deems appropriate to have a hearing to address the changes in the conditions, can do so and has authority to make that determination itself under the criminal code. So this is an interesting case. It really sets out a new test, and here we see the Court of Appeal trying to provide some guidance to institutions who are clearly struggling with this idea of what amounts to a significant increase in restriction on liberty. So again, a fact-specific, a case-by-case analysis, but the important thing to consider is what was the individual actually experiencing before the change, not what were they entitled to. Another issue that's come up is the resource issue, the practical issue of what does a hospital do when a court has issued a treatment order. And as we recall, that means that a patient must be treated forthwith for a period of no more than 60 days. And how does a hospital respond to that if they don't have an available bed? So in the case of CAMH v. Ontario, the Supreme Court of Canada, our highest court, considered this issue. And in that case, a treatment order had been made, but the hospital did not have an available bed for 6 days. And the issue was, is a patient being treated forthwith if they're not being treated until the bed is available almost a week later? So the hospital was actually the body that appealed this decision to try to get some guidance. And at the Court of Appeal stage, they held that implicit in a hospital giving consent to accept a patient under a treatment order is the understanding that the hospital will have the necessary facilities, personnel, and beds available so that the order can become operative. So that's an important part of consent. And the Supreme Court did uphold an institution's right to deny consent and not to accept a patient pursuant to a treatment order until a bed is available. However, they did leave the open-ended caveat that in some what they've called exceedingly rare circumstances, a refusal of that consent may violate a patient's Section 7 rights under the Charter. It seems that this would be unlikely, and this case seems to be reinforcing the institution's ability to control how they're receiving patients based on their resources. Another hot topic that's coming up in the courts is access to the internet. And this came up also fairly recently in 2014, and the Court of Appeal considered this case. in this particular case, a condition was imposed by the ORB that permitted the hospital to monitor the internet access of an accused. And in this case, that accused and detained person was a dual status offender who was considered a high risk for sexual violence. And in the course of monitoring the internet access, the hospital came to realize that this offender was making contact with a woman in Mexico, using the internet, and they deemed that those interactions were inappropriate. The hospital documented this, and the treatment team identified that computer and internet use was a risk factor, given this accused treatment status and his availability to access potential victims. And the Court of Appeal found that this computer condition was reasonable. They found that in certain situations, monitoring and removing access to the internet is reasonable. And the key things to remember here that if there are concerns, they need to be documented. That was an important part of this case, that the treatment team had actually documented their concerns with this patient's use of the internet. But this case also establishes that the Ontario Review Board does have a broad mandate and can really make these orders with specific conditions, such as removal of the access to internet, which kind of ties back into the charter rights of freedom of expression and what are patients entitled to. There are situations where those rights can be appropriately limited. Again, it's important to keep in mind the treatment decisions and to document the reasons for making these types of decisions.
Now we're going to talk a little bit about some of the special challenges for non-Schedule I facilities, and by that I mean hospitals that are not designated psychiatric facilities or other mental health and addictions organizations within the community. In these situations, there is no authority to detain persons under the Mental Health Act. However, individuals will often be brought in or will require treatment in a Schedule I facility, and there's a need to temporarily admit and treat the person pending transfer to the psychiatric facility. So it may be that the individual has been brought in by the police or has been brought in on a Form 1, and the organization is trying to organize a transfer. Or it may be a case where the attending staff in the facility has place the individual on a Form 1. So there have always been challenges in these situations. Because there's no authority to detain these individuals, they are voluntary and have the right to leave. There's a need to balance to ensure the safety of all patients and staff while pending transfer. And so really what we're looking at are some of the common law rights relating to restraint without consent, where immediate action is necessary to prevent serious bodily harm. This requires the exercise of clinical judgment and trying to get agreement from the individual to stay.
Another issue that comes up, similar to the challenges with restraints and restraining patients, is also the challenge with searching patients. So, a patient may come in and it may be quite apparent that there's some inappropriate object or contraband on the patient's person or in their belongings. Now, there's no authority to search a patient's body or their belongings without consent. However, again, this runs up with the institution's conflicting obligation to ensure safety of the patient himself, him or herself, and of staff. So there's a few strategies here, and of course it depends on the situation. One is to ask the patient simply to turn over the item to avoid the need for a search at all. Certainly, if practical, you can seek consent to search on a case-by-case basis as the issue arises, or more generally, seek consent from the patient to searches in general as part of the treatment plan. It's not always feasible, but if possible, the option to discharge a patient or refuse admission where there's a reasonable belief that there's a dangerous item or contraband or something that might be harmful, and if necessary, the last resort of calling police. The main issue that comes up often for non-Schedule I facilities is the issue of transfer of a patient to a Schedule I, to a psychiatric facility. And again, we come across that common and ambiguous legislative term of forthwith. So the Mental Health Act requires that a person subject to a Form 1 be apprehended and taken to a psychiatric facility forthwith. And we know that this forthwith doesn't mean immediately, and actually from the case law we know that it means as soon as reasonably possible, which is still a term that depends on the facts of each situation. So how quickly a patient can be transferred will depend on a number of circumstances, and it ultimately kind of becomes a clinical judgment of the team at the time. But what is important is that the physician who completed the Form 1 should make a clinical assessment as to how the individual can be safely transferred, keeping in mind his or her specific physical or mental health condition. And if there is a delay in transferring the patient, it's probably a safe bet and probably a good idea for a further or a second clinical assessment to be undertaken to ensure that there are appropriate conditions in place to ensure a safe transfer. So now we kind of get to the wrap-up.
Yeah, so how, given all of these different obligations, how do you as an organization comply with your various legal obligations? Going back to the beginning, knowing the authority under which the individual is being treated is key to understanding the rights and responsibilities that flow from that. Consider what legislation might be applicable in circumstances, whether you are looking at a new program, a new policy, or changes to existing ones, and undertake a risk analysis. Identify if there are any conflicting or competing obligations, and determine if it's possible to resolve those issues, or if not, look at the balancing those rights, document your risk analysis and your rationale, and this can be supported by a policy or a process to support this type of an analysis. Often there's no one right course of action, but the key is to be able to, as an organization, show that you were aware of the various considerations, you considered them, and you have a rationale for the actions that you've taken.
So that concludes our speaking portion, and I see that we do have some questions that have come in on the chat box, and I'll read aloud the first one. The question is, with a non-psychiatric facility, if a physician feels there is a significant risk to the patient, can the police be called and the patient returned under a Form 9 using the Mental Health Act as in Section 6.3 of PHIPAA? The patient has been issued under a Form 1 waiting transfer to a mental health facility.
So a Form 9 is typically issued after if the individual leaves and they've been detained. In the circumstances where there's an immediate risk to the patient, the patient can be returned to the organization where there's been if they leave without while they're at risk. And in those circumstances, if they were to leave, I would always suggest that the police be contacted, that they understand the risk to the individual, and so that they have the information that they need in order to conduct a search.
Second question that's come in on the chat box is, with respect to searching a patient's belongings, is it possible to seek consent from a substitute decision maker if a patient lacks capacity? The answer to that is yes. If the patient lacks capacity, then treatment decisions, including consent to searching belongings as part of the treatment plan, can be sought from the substitute decision maker.
Yeah, and keep in mind as well that when we're searching patients' belongings, there's a difference between those that are visible. For example, if there's a hospital drawer and the items are in that drawer, there's no need to have consent in those circumstances. So it's really when we're looking through the patient's belongings where you need consent from the individual. Whether or not consent from a substitute decision maker will apply in certain circumstances, it really depends on whether it is part of treatment. Even if it's not, it's good practice to speak with the individuals, to the patient's companions to get that consent. Thank you very much for attending this morning, and we look forward to seeing you next time.